Constitutional Court has dealt independent candidates some reprieve. The Apex Court has found that the 15% signature requirement is not necessary and that independents need 1,000 signatures. We speak now to Newzroom Afrika's Junior Khumalo, who is standing by. He's been following developments at the Constitutional Court for us. Let's take a look, listen at this first though.
The applicant was required to show that the measures adopted by Parliament constitute a limitation of the political rights alleged. For the reasons stated, the applicant has failed to discharge these onus, and as such, the 200-200 split passes the second leg of the Walters test. It follows that the Section 19 challenge must also fail. Due to this conclusion, it is not necessary to conduct the justification analysis under Section 36 of the Constitution, as I have concluded that the impugned schedule does not violate any of the fundamental rights alleged by the applicant. To sum up, the applicant has not established that the impugned legislation is irrational, nor that it infringes a provision in the Bill of Rights. Therefore, it has not made out a case to justify the declaration of constitutional invalidity. It follows that the application must be dismissed. Following the principle set by this court in BioWatch Trust versus Registrar Genetic Resources, each party must pay their own costs. In the result, the following order is made. 1, direct access is granted. 2, the application is dismissed. 3, there is no order as to costs.
Newzroom Afrika's Junior Khumalo is at the Constitutional Court. And Junior, are you standing by to tell us about some independent candidates who are now breathing a sigh of relief?
Indeed, to do so. There were 2 judgments by the Constitutional Court today, both of them following a challenge of the constitutionality of the amended Electoral Act. The first judgment that we just heard right now from Justice Nonkosi Mhlandla was a unanimous judgment where the Independent Candidates Association had approached the Constitutional Court and asked for direct access. They were granted the direct access, but their application was dismissed. So they had a problem with the seat allocation in the National Assembly. Of the 400 seats in the National Assembly, independent candidates can, according to the amended Electoral Act, only contest for the 200 seats. So they say this was biased against them, but the court found that this was not, so that application was actually dismissed. But the second application was brought by One South Africa movement, in which they were basically challenging the signatures required for independent parties or parties that are contesting the national and provincial elections for the first time. So the signatures that were required according to the Amendment Act was about 1,000 and 14,000. So this is 15% of the votes required to get a seat in the National Assembly. The court found that this was actually biased. It was invalid and biased towards independent candidates and parties that are contesting for the first time. Parties that are represented already in the National Assembly are not required to get the same amount of signatures before they can contest. So now what the court has said is that there is a judgment that only 1,000 signatures are now required from independent parties, as well as parties that are contesting for the first time. So this judgment is actually suspended for a period of 24 months, so it doesn't have to go to Parliament. So now it is applicable to the upcoming national and provincial elections due to.
All right, and then on the other issue, Junior Khumalo, more so the issue of the court finding the recalculation application, or rather dismissing the recalculation application. Talk to us about that.
Indeed, to do so. The second application by One South Africa was actually, there were 3 judgments in that matter. So there wasn't a unanimous judgment. The Chief Justice and 3 other justices found that there was no problem when it comes to the calculation of signatures in that situation. But the Justice Khumalo and others found that this was invalid and constituted a bias to the independent candidates as well as parties that are contesting for the first time. So that's how the court ended up finding that the signature requirement should actually remain at 1,000, because before the Electoral Act was amended, all the parties were actually required to only get 1,000 signatures. But after the amendment of the Electoral Act, to try and restrict the number of independent parties that can contest or just apply to contest, they made the requirement a bit stringent, meaning that there were about 10,000 to 14,000 signatures that were now required. And the court has found that this was invalid and constituted an unfairness and a bias towards independent candidates as well as parties competing in these elections for the first time. So that's why the judgment was set at only 1,000 signatures, and this will be applicable to the elections that are upcoming, Dudu.
Junior Khumalo, thank you very much for that report. No doubt we'll be taking a look at this in the course or during the course of the day. The rest of it, what's left of it, as into the evening in the coming